Good afternoon, everyone, and thank you, Teresa, for joining us this afternoon as our presenter. Today's topic is emergency preparedness in transportation of radioactive materials. And Teresa McClenahan is our presenter. Teresa is the Executive Director and Senior Counsel at the Canadian Environmental Law Association. So thank you, Teresa, and I'll hand it over to you. Moving to our first slide, jurisdiction.
Okay, so jurisdiction. So first, I know some of you would have been, probably quite a few of you would have been online last year when I did a presentation about emergency planning in general at the nuclear plants and considering what the rules might be around a fuel waste facility. So I'm going to focus more on the first half of this deck this year because this is new content specifically focused on transportation. But this first slide is only slightly tweaked from last year, just pointing out that in Canada we have a division of topics and matters between the federal and the provincial government, and for the most part nuclear matters and nuclear licensing are federal or Canadian, but we still do have some provincial laws that apply. Most of the provisions relating to radioactive materials transport are federal, but we still would have some applicability of our provincial, well, not more than, we would have applicability of our provincial nuclear emergency response plan if there was a transportation accident in Ontario. So turning to slide 2, transportation of radioactive materials. So first of all, this is a very, very big activity. It's occurring to the tune of 1 million shipments of packages per year, according to the CNSC. And I remember hearing this a statistic for a portion of this on the Great Lakes during one of the hearings, I think the one dealing with the steam generators a few years ago, and being pretty surprised at the large numbers of shipments. But for Canada, in terms of all types of radioactive materials, it's over 1 million shipments a year. Most of these are not separately licensed. There's a system of using certified packages, which I won't really get into today. It's very detailed system in terms of specifications, which is not necessarily to say that we're happy with the confidence in the packages, but there are detailed specifications. And those packages come in different types and are certified. And so if the shippers are using certified packages, then unless they meet one of the other exceptions in the Act, they don't need a license. However, other shipments are licensed, in general, the higher risk shipments. So certain types of materials, materials that could present a security risk, large objects like the steam generators, that's one of the reasons, as well as the fact that it was being exported. And as well, what I'm not dealing with today is the export permit system, which I know many of you are familiar with from a couple of notorious cases. So how are they shipped? They're shipped by road, by rail, by water, and by air. So the regulations define, which adopt the IAEA regulations, define conveyance as all of those items, and all of them are used in Canada. We switch to slide 3. The statutory provisions are covered under both Transport Canada and Canadian Nuclear Safety Commission's legislation. For the most part, in the last decade or so, Transport Canada has acceded to the CNSC issuing the regulations and conducting any reviews and licensing, if any is needed, for the larger or higher risk packages. So there's a relatively new version of packaging and transport regulations from 2015, and they refer to the IAEA, the International Atomic Energy Agency's regulations for safe transport of radioactive materials from 2012. So I've given you links throughout these materials for anyone who wants to go back and look at them in detail, because if you were dealing with a specific proposal or a specific license application, then you may well want to go back into some of the details in any of these documents. Slide 4 deals with Reg Doc 2.14.1. So this is brand new this month. The CNSC published the final Reg Doc. They had consulted on it and they had discussed it at commission meetings. And it's called Information Incorporated by Reference in Canada's Packaging and Transport of Nuclear Substances Regulations. And I suspect it was, as it says here, at the request of the industry, because there were so many regulations and guidance documents that it helps line up what the provisions are in the various pieces that are being referred to. But it's useful for us too. I found it useful in preparing today, and I know for any of you who are involved in any of these issues, you would probably find it quite useful. And if you had a matter you were actually engaging in around radioactive transport in Canada, I would start there because it'll, for the most point, then direct you to which of the other regulatory documents and IAEA documents you need to go look at depending on what you're dealing with. Slide 5 talks about a license to transport. So when there are security risks, as per the International Convention, and Canada is obligated to ensure that it is meeting its obligations under the convention, then licenses are needed. And so there are additional requirements specifically for materials that are defined as potential security risks. And they're also additional to the generic regulations. So they require a written security plan, but I want to point out that we would not necessarily see this information. It's limited to those with a need to know. And you'll know from the HEU controversy or from the steam generators controversy. Well, the steam generators, we had a pretty good idea of the route and the mechanism of shipment. And the MOX controversy, that we don't necessarily know dates of shipment or exact routes, that kind of thing. So what has to be included in the security plan for approval by the minister or by the CNSC is the description of the nuclear material, a threat assessment, description of the conveyance, what they propose for security measures, what communication arrangements they've made among themselves and the vehicle operator and the recipient of the material, and any off-site response forces along the route, and what arrangements they've made with off-site first responders along the route. I'll say more about that in a few moments. What the planned route is and what alternative emergency routes are if they can't take their planned route. So knowing that that kind of information is what needs to be provided at least gives us some things to be speaking to, even if we don't get all of the details in a plan when there is a consultation, for example, for an export permit. And we can be surmising, as we do, what the route might be and raising issues and questions about the adequacy of the ability of first responders to respond, for example, or ability to get emergency equipment in and so forth. Slide 6 is the emergency response plan slide. Brene, let me just double check. Is sound quality okay?
Yeah, sound is good, and we're on track for slides. Thanks, Teresa.
Okay. Yeah. So the emergency response plan is a general requirement. So even though I said earlier that most shipments, the large majority of shipments, are being shipped in certified packages and not being individually licensed, nevertheless, they all have to have an emergency response plan, and that needs to be approved by the minister or with an interim approval, or if some issues are arising, the minister can revoke it. And the plan must outline what is to be done to respond to an actual or anticipated release of the dangerous goods in the course of handling or transporting the material. I should add that this is not limited to radioactive materials. All dangerous goods have to have an emergency response plan, so that's why it's worded in that more general way. Slide 7, and I'll say more about that again in a few minutes when we get to some training slides. Slide 7 defines dangerous occurrences in the Federal Packaging and Transport of Nuclear Substances regulations. And so it's a number of different things that could happen. First of all, if the conveyance itself is involved in an accident, so the truck or the railway car or the ship. Secondly, if the package shows any evidence of damage or tampering or leakage or its integrity has degraded. The third example of a dangerous occurrence is radioactive material that's lost or stolen or not in the control of the person who is supposed to have it. The fourth is where radioactive material has actually escaped from a package or a containment system during transport. The fifth is fissile material outside confinement during transport. The sixth is a specified level of non-fixed contamination, although I should say that elsewhere in the regulations this does not necessarily apply on the interior of containers that are designated exclusively for transport of radioactive materials. They have exceptions for these limits, but otherwise these limits are a trigger for a dangerous occurrence if they're found. And then finally, any failure to comply with the Act or the regs or the license that may reasonably be expected to lead to a situation where the environment, health and safety of persons or national security is adversely affected. So basically a judgment call on the part of the shipper or carrier or consigner that's a catch-all where they ought to know that they ought to consider something a dangerous occurrence. Slide 8 is what happens then after we have a dangerous occurrence. So let's say we had an accident involving the conveyance in some way, the truck or the railway car. Then what happens? What has to happen? So the regulation sets this out in Section 36, and first of all, it's an obligation on a multiple number of parties, the consigner, the carrier, the consignee, or any other person who controls the area. I'll talk about who they are in a minute. Their obligation is immediate, and they have three things they have to do. They have to limit access to the area, signs, barriers, personnel. They have to prevent dispersal of the radioactive material to the extent possible, and they have to record names and contact info and quite a bit more personal information of persons who may have been exposed to radioactive materials and to ask that they remain available for assessment by an expert in radiation protection. So if we turn to the next slide, who are these people? The consignor is the person who's sending the shipment. And so it's the person who's named in the shipping document or the person who's importing dangerous goods or the person who had possession just before they were transported. The consignee is the person receiving the shipment. And there's a caveat there tied to the IAEA regulations where it's a person, organization, or government entitled to take delivery of a consignment. So there's a legal obligation to be entitled to take delivery that goes with this definition of consignee. And then the carrier is the person, whether or not for hire or reward, who has possession of the dangerous goods while they're in transport. So in other words, that would be the airline company or the shipping company or the railway company, et cetera. So turning to slide 10, just a few things to think about around Section 36 that you might want to think about if you're engaged in looking at a transport issue is depending on where the accident were to occur or the dangerous occurrence, the consignor and others with the equipment and monitoring devices and experts may be some distance away. So that's the first and most practical issue. So the question is, has there been provision to have equipment available in close proximity to the transport? I'll include later a reference to a link to a very high-level description by an NWMO contractor about what might be happening for high-level fuel transport. And in that case, they were envisaging having some type of equipment basically accompany the shipment. But I'm not sure that would always be the case, especially for more routine shipments. The second issue is that the consignee, i.e. that should be the carrier. That's a typo there. The carrier has immediate control, and assuming that the driver or the staff are not themselves injured, they're supposed to have the expertise and equipment to comply with the regulation according to the regulatory requirement for an approved emergency plan. And I'll say more about this in a few minutes on training, but the concern I have is that the training requirements are very high level for carriers. And so again, there would be a very practical and appropriate question to ask in any particular issue that you're looking at, is whether or not the staff involved actually do have the training and how detailed it is and how competent they would feel or in fact be to take control of the situation. And then, of course, depending, again, if it was an accident, the person who controls the area could include the Ministry of Transport if it's a highway, or a railway company if it's a railroad, the Crown if it's land in Northern Ontario, for example, or private landowners. And again, the question is, would the expertise and equipment be immediately available? Never mind would people in those cases even know they had any kind of duty at all. Slide 11 is assessment and reporting. So there's an obligation on all of these specified parties, consignee, consignor, and carrier, to, as soon as feasible, have an expert in radiation assess the situation and to provide an assessment to the CNSC as soon as feasible. So you will obviously see, as I do, that that's quite vague. And when they do that is as soon as their obligations that I reviewed a minute ago are complied with. So first they have to secure the site and that kind of thing, and then they have to make arrangements to get an expert to assess the situation and then provide that to the commission. They also must immediately notify the consignor or the person who arranged to make the shipment if that person or party is not already aware. So slide 12 is the content of the reports. So first, dealing with the preliminary report, it has to outline the location, the circumstances of the dangerous occurrence or the failure to comply with the reg, whatever it was, and any action they've taken so far. So the preliminary report, one would expect to be relatively brief without a lot of detail or analysis. Slide 13, within 21 days, they need to, and again it's on all of them, must file a full report about the dangerous occurrence with the CNSC. And this includes date, time, location, the names of the persons, details of the packaging, probable cause in D, E, effects on the environment, health and safety, and security that have resulted or may result. They have to include in the report doses that any person has received or is likely to have received, and the actions taken to remedy the failure and prevent its occurrence. Before I leave this slide, we know this is not an academic kind of question, because if any of you were tuned in, Bernayne, was it the December or the January Nuclear Safety Commission meeting? They were considering an event where a dolly holding a radioactive waste package that was destined for Savannah Ridge broke, and the package was dropped at Chalk River Laboratories. And so about 2 hours of the Commission's meeting that day was taken up with Commission members berating CNL and their staff about the fact that it hadn't been immediately reported. And the members quite rightly considered that, quite an egregious failure to appreciate the duties both on the part of their staff and on the part of CNL. If any of you look back at my tweets from that day, one of the quotes was from one of the CNSC staff members saying, "Well, things happen at the plant every day." It was sort of their answer to why it wasn't immediately escalated, which I thought was something telling or alarming or something. So turning on to slide 14, first responders could very well be the person who controls the area. And again, a question arises as to whether they would be equipped to comply with the regulation themselves, whether they have the training, whether they have any necessary equipment. As I mentioned before, the question about carrier staff is also worth asking. So if you turn to slide 15, Bernayne discovered when investigating this recently that first responders training in Ontario for radioactive and other hazardous biological materials accidents is by way of a self-study course. It's actually available to everyone, at least it was. But the current course is undergoing revision and is not presently available. And when it's available, it will be available on the Ontario Fire College Educational Materials website. So I have not had an opportunity to follow up with the Fire Marshal's office, which I will do, but I was concerned in several respects that it's a self-study course, which, by definition, and online, which means that there's no actual experience or training happening with real packages and real monitoring equipment, et cetera. The second concern, of course, the biggest concern, is that the training is not currently available. And I don't know how long that's been the case and how long it will be the case. Slide 16, for me, raises some similar concerns. There's a guidance document, GD 314, issued by the Canadian Nuclear Safety Commission, about carriers' obligations to have radiation response plans. And so this guidance indicates what would be the elements of an emergency plan. So they include the name of the person responsible for their emergency response, a phone number, and any other relevant information. So if you switch to the next slide, Bernayne, I won't read all of this, but I included for later reference an excerpt out of the guidance, which reminds carriers that they have a mandatory need to train anyone referred to in a radiation response plan, and further, elsewhere in the guide, a mandatory need to document written work procedures. But if you look at this later, you'll see that the guidance itself is very high level. So even though it says it's supposed to be related to specific jobs and include detailed actions, then it doesn't really get into the kind of actions that would be needed, other than saying the training should explain, time, distance, shielding, and the driver should not be sitting beside the package. And if you read the whole guidance document, there really isn't much more guidance there to be found. Presumably, carriers bring in, I would hope they would bring in radiation safety experts to prepare their plan and then to prepare their training plan and to train their staff. But just like emergency planning and the concern I've had over the years with that, my worry would be the extent to which this is happening in actuality, the extent to which it's being audited by anybody, including the CNSC, and the extent to which it's ready to hand in terms of response by carrier staff. And, not just that they had a high-level training 6 years ago, but that they actually are drilled enough that they would know exactly what to do in the particular situation. Turning to slide 18, another issue I noted when I was going over the reference materials is the one raised in IAEA guidance SSG 26, and that is the potential for chemical reactions in accident conditions on top of the radioactive material risk, and the situation can be made much, much more complex and dangerous. And again, if you are engaged in a proposal, responding to a proposal, it might be worth taking a look at that link and at the two sections I outlined there to determine whether you think questions have to be asked about the potential for that kind of interaction. So corrosive materials, for example, or chemical reactions, and other issues, the possibility for gas reactions that could make the situation much more dangerous. And then, of course, if so, back to the question about equipment, training, contingency plans. Slide 19 is general provisions that apply. So I'm not going to spend a lot of time on these because I covered them last year, just to point out that there is the overarching responsibility of the Commission to limit risk to national security, health, safety, and environment to a reasonable level. So that's something whenever you're making comment on proposals, link back your comments to their basic obligation here. And also slide 20 reminds us that they do have a number of extraordinary powers that can be used, like warrantless searches, inspection, power to issue orders, that kind of thing. So if there were any reason that you ever became aware where you thought that needed to be invoked, those powers do exist, and you can be suggesting that. The notification slide, I wanted to include again because I just think it's important for people to realize that there are phone numbers, and I've included the Ontario, Quebec, and Manitoba numbers in this slide, the next two slides. And I'm not sure about, and I'm sorry I don't have the Saskatchewan one I should have had. I'm not sure about the situation in the other provinces. Well, actually, it does say this here. For Quebec and Ontario, arrangements had been made with the provincial centres to take spills reporting, regardless of whether the underlying jurisdiction for the substance or the activity is federal or provincial, which makes total sense because somebody, seeing an accident on a highway with a truck that has a radioactive materials label isn't going to have any idea, what's federal, what's provincial. They just need to call the number. And so Ontario, for example, has then a tree that they go through to notify if it's radioactive, to notify the CNSC. Turning to slide 23, the Federal Emergency Response Plan. Again, I covered this last year. I just wanted to keep the slides in this deck because it is still directly relevant to transportation accidents. And Transport Canada would have responsibilities around technical advice and directing traffic over and above the provincial authorities. And then, so Renee, go past the next Federal Nuclear Emergency Response Plan and go to the Ontario Nuclear Emergency Response Plan, slide 25. So this one, and I'll give you a link at the end, but this one is under review by the province. We haven't seen it publicly yet. They have said at the licensing hearings last fall and last spring that they will be consulting the public this year. It was originally going to be first quarter of 2016, but it now looks to me like it'll be a bit later than that, maybe second quarter. And in the meantime, the City of Toronto Executive Committee passed a resolution asking their medical officer of health to report back on the planning basis, and Durham Region passed a similar resolution. So this will be a very live topic this year, is what's the planning basis for the province of Ontario's Nuclear Emergency Response Plan. And that will give us an opportunity to look at any of the specific hazards in more detail, including transportation. So slide 26 is a slide that I included because there isn't detailed planning for more severe accidents, no matter how they might happen, whether nuclear power plant or transportation. Instead, there are generic instructions about timely public alerting, prioritizing evacuation, providing radiation monitoring, and if necessary, decontamination, and medical assessment, treatment, and counseling if necessary. And these are just provided at a very high level that these are the types of things that would have to be considered if there was an event which could include a transportation event that the provincial plan was responding to. Slide 27 just gives the excerpt about if there were special circumstances like unexpected accidents, what are some of the things they would consider doing. And slide 28 is just a reminder about what if they're transporting fuel waste, which is not presently happening. And there's not yet any specific nuclear emergency response planning for fuel waste. So at the moment, what is in place is the reference in the provincial plan to set up a downwind protective action zone for monitoring and control zone, including hot and warm zones, if necessary. Slide 29, the existing plans. I'm just reminding you that if you need more about emergency planning for the commercial power plants, CELA has done an enormous amount of work on this. I made a presentation to this group last year, which should be on the Nuclear Waste Watch site, but also we have the individual presentations we've done for each of the licensing hearings over the last several years posted on the CELA website. So then the next slide is the Radiation Health Protection Plan, which I will mention again, even though I did cover it last year as well, because we were waiting for a long time for this. It took a long time for the province to finally do it and release it. But so any accident from transportation would be called a radiological emergency under the Radiation Health Protection Plan. And so it would apply when there was an actual or potential hazard to public health, property, or the environment. So slide 31, again, uses the principles of time, distance, and shielding. The idea being those responding should try to reduce the time of exposure to the public, increase the distance from the radioactive source, and shield people from the source, albeit, remember, shielding is not suitable for all types of radionuclides, depending what it is and what kind of shielding you have. Slide 32, continuing with the Radiation Health Protection Plan, talks about what are some of the types of things you could do in terms of protective equipment, controlling loose particulate matter from spreading, decontaminating individuals, which if you get into the plan, you'll see talks about showering and washing clothes, and sometimes appropriate pharmaceuticals, Prussian blue or potassium iodide. So my concern with, on the next slide, with the Radiation Health Protection Plan is that, again, medical treatment may have to be provided by first responders. Given everything I've been looking at around emergency planning in Ontario in particular, I am far from confident about the capacity of first responders and the hospital to handle very many victims. For example, the exercises that have been run, the interjurisdictional exercises that have been run both at Bruce and at Darlington have assumed only a couple of contaminated victims. In any event, certain hospitals are designated to be part of the provincial response in the case of chemical, biological, radiological, and nuclear hazards, and they're expected in particular to be able to handle a contaminated victim. So I'm on to the next slide, Bernine. And what they have to be able to do is screening for exposure, triage, monitoring external decontamination, reducing internal contamination. And then if we go to slide 35, the designated hospitals, the ones that have been designated for radioactive incidents have been done in relation to the nuclear plants. So the Kincardine Hospital, the Ajax, Pickering, Lake Ridge, and Bowmanville hospitals, Pembroke, and Mill Hospital has been designated around Fermi for Ontario. And then there's a radiation trauma unit at Toronto Western designated as the tertiary hospital to treat acute radiation exposure from anywhere in the province. So slide 36 talks about the response teams. They're located in Windsor, Toronto, and Ottawa, and other municipalities would use their hazardous materials teams, the OPPs, Urban Search and Rescue, and CBRNE teams or similar teams that RCMP and Canadian Forces have. And then there is I believe it's one mobile emergency unit that Ontario can send within 24 hours anywhere in the province. And then we have international assistance agreements as well. Slide 37 just points out that the way the Radiation Health Protection Plan works is by way of scenarios, and one of the 18 scenarios involves transportation of radioactive substances. So turning to slide 38, NWMO, the link that I gave you there is the one I mentioned earlier. It's a SNC Lavalin consultants report dealing with what would be put in place in case of an accident transporting fuel waste, and they talk about having specialized equipment to retrieve the package, and otherwise they reference to the type of emergency plan that the generic regulation requires. They assume they will have been in communication with first responders along the route and so on. And then the last slide is to say that, as I mentioned, the province is reviewing its nuclear emergency plan have not happened since Fukushima is now underway. They have not been sharing their thinking with the public, much to our immense frustration. And the thing we've been saying to them is that there needs to be detailed public consultation and input on the plan, and particularly on the planning basis for the plan. And I would say things like scenarios would be the kind of thing you'd want to engage in, as well as how severe an accident they're planning for. So I think that gives us about 15 minutes for discussion, according to my watch. So I will stop there and turn it over to you, Brene.
Great. Thank you very much, Teresa. I'll just turn off the recording and we'll go to question and discussion.